third respondent.
Second and third respondent.
My Lord, I appear for the 10th and 11th respondents.
Please inform Mr. Studio I appear for the 18th respondent.
My Lord, I appear on behalf of Media Monitoring Africa, the applicant for admission as amicus curiae.
You haven't been admitted as an amicus yet.
That is correct, my Lord. That's why I indicated applicant for admission as amicus curiae.
Okay, so you want to apply to be admitted.
My Lord, we have filed an application for admission. As
I've read the application. I found it somewhere. Yes. You think you can add anything useful to these proceedings? If so, you may be admitted. I'll accept your word for it if you can add something useful to these proceedings, Mr.
Yes.
Magadi.
My Lord, in the application we've addressed two specific issues that we think we can assist the court on. The first relates to the public interest element in the parliamentary inquiry. And the second aspect, which we've dealt with in our heads of argument, which I'll hand up if your Lordship is inclined to allow the admission. The second aspect deals with the nature of the Section 15A1 inquiry. Now, we do accept that to a certain extent there may be an overlap on some of these issues, but we would submit that given the interests of Media Monitoring Africa, which was admitted as an amicus curiae in a number of related applications, and specifically was the complainant in the complaint which went to ICASA concerning the SABC's editorial policy. That issue is one of the issues that has been raised by the 10th to 11th respondent as the basis on which it is contended that this particular type of parliamentary inquiry is necessary. In our heads, we've dealt specifically with certain aspects of that.
Regarding, we don't have to go into entire argument now.
Yeah.
I think I'm persuaded to admit you as an amicus.
As it is good.
And I'll let you argue in due course.
As it is good.
But let me, Mr. Jamie, on what authority do you appear before me?
On what authority?
Yes. You appear for the 18th respondent.
That's correct, Judge.
But now, who's appointed you?
My attorney who sits in front.
No, but who's your client?
Judge, my client is the SABC.
Yes, but now, your client is dysfunctional to the extent that it no longer has any non-executive directors. There's, as I understand it, one non-executive director left. So if it's in court, how does it appoint you to act for it?
I'm sorry, Judge, are you not conflating the board and the SABC?
No.
My client is the SABC, not the board.
Yes, even the SABC. I mean, somebody must appoint you.
The SABC cannot be in court, Judge. The SABC is...
So the SABC board is in court.
The SABC board is in court. I do not act for the SABC board. I act for the SABC.
So
which is the 18th respondent. I've been brought to court. So I'm entitled to be here. But more importantly, Judge, if
now, whose interest do you represent? The board or the corporation?
Of my client, the SABC. And moreover, Judge, as you'll be aware, it's trite authority that the challenge by anyone to the authority of a party appearing in court has to be raised in terms of Rule 7.1, not by any traducing of the
So you appearing here by virtue of the fact that you cited as 18th respondent?
And by virtue of the fact that my attorney has instructed me to, yeah.
Yes, but has the SABC adopted any resolution to permit you to act on
Judge, there are two decisions of the Supreme Court of Appeal. I don't have them with me because I didn't expect my presence here to be controversial.
No, it's not controversial at all. I mean, I just want to be absolutely sure,
but
in my own mind, who you're acting for.
I act for the SABC.
Yes.
The two authorities are ESCOM and GAINS. ESCOM versus, I forget the full citation. Both of those, and they're fairly recent cases, Judge, one by your erstwhile brother Brunt, and they are authority for the proposition that...
My erstwhile? Oh, he's retired, but he's still very much alive.
Not erstwhile in the mortal sense, Judge, but the judicial sense.
Good.
Both cases say that The only way that you can challenge, anyone can challenge the authority of a party to be in court is via a challenge to the attorney.
No, I'm not concerned about the fact that you're a party, you're clearly representing a party. But what concerns me is the Broadcasting Corporation must pay your costs to be here.
I would sincerely hope so, Judge.
That's yeah, also.
Unlike Mr. Katz, I don't act pro amico very often.
You're not acting pro amico with the
No.
board. But somebody must approve your being here.
My being here has been approved, Judge. Mr. Aguma has deposed to an affidavit. Mr. Aguma is the acting chief executive officer.
That is the last man standing.
Doesn't matter, Judge. I'm not required, on the authority of Gaines and ESCOM, I'm not required to prove my authority by virtue of a resolution. It suffices that I'm instructed by an attorney of this court. That gives me
No,
authority
I'm not.
to appear.
I mean, you're perfectly entitled to appear, instructed as by your attorney as counsel. What concerns me is who your client is in the absence, in the light of the fact that the SABC board is disintegrated.
I'll repeat, I don't act for the board.
Yes, I know that. You said that before. But what concerns me is who's appointed you here.
I don't want
Besides
to.
the attorney.
Judge, if this is an issue for you, then I'll request the matter stand down. I will give you the authority. The authority is very clear. I don't require to prove a resolution by anyone to appoint me if I'm appointed by an attorney. The old manner of challenging the authority of a party to litigate by going through the minutes and asking for resolutions, etc., is no longer good law in the light of those two cases.
You don't teach me the law, Mr. Jamie.
But you're asking me.
Yeah, what I'm concerned about is the fact that the board no longer exists. You don't act for the board, but you act for the corporation.
That's correct.
So somebody must have decided to appoint you, besides your attorney now.
You can safely accept that, Judge.
And ultimately, SABC will have to bear your costs.
They will indeed pay my costs.
But on the face of it, the corporation's board hardly exists presently.
The board is not responsible for day-to-day administrative actions on the part of the corporation.
Yes,
Judge.
but well, let's deal with it later in argument.
If you so wish, Judge.
Okay, let's hear the applicant. Mr. Masuku, what do you say about your client appears he acts for himself, not for the board?
Yes, he acts for himself.
So he's not subpoenaed in his personal capacity to this hearing, but it's the board that is the subject of this inquiry for Parliament.
My Lord, if one looks at the subpoena,
Sorry?
if one looks at the subpoena, it is directed at him.
Yes, but he's
is
subpoenaed qua chairman of the board.
Yes, that's correct.
The inquiry is not an inquiry into him as such. The inquiry is an inquiry into the malfunctioning or dysfunction of the board.
That is correct, my Lord.
So what is his interest in these proceedings? Just as chair?
So, his interest is self-evident, my Lord. As my little colleague, I didn't expect that you would ask the question about the interest of a party who has been subpoenaed to appear before a parliamentary portfolio committee.
Yes, but he's
under the
subpoenaed
threat.
in his capacity as chair.
That is correct, but
But he brings this application not as chair of the board, but he's in his personal capacity.
No. If my Lord looks at the capacity in which he brings the application, it does say that he is the chairperson of the board. So there are two components to it. To the extent that the subpoena itself threatens threatens to with criminal sanction, he does. That's a personal effect that would entitle him to come to court and challenge the subpoena. But he does say, I am a male director and chairperson of the South African Board, South African Broadcasting Corporation, appointed as such by the President of the Republic in terms of Section 13(3) of the Broadcasting Act of 1999. I'm authorized to bring this urgent application and seek the relief in the notice of motion. None of the parties have taken the authority to bring the application. Before you accept the 10th, accept the 10th and the 11th, who only raise the fact that the board is dysfunctional to the extent that it's not correct, and it's not able to take decisions relating to the governance.
It's not that the board is, it's more serious than being dysfunctional. It's in fact non-existent.
Yes, no.
If it reaches a stage where it's incorded to the extent that this one is, it's in effect non-existent.
Can I then put it this way, my lord?
Yeah, put it differently.
If for example, the subpoena that we seek to have set aside is executed, what are the rights of the chairperson of the board? The rights of the chairperson of the board are at stake. He's entitled to come to court to seek an order setting aside a subpoena given against him.
Yes.
That is the standing in which this application, he is standing to bring this application. He's also entitled, even as the chairperson of the board, to have to appear before an ad hoc committee that is independent and is impartial. Those are very important considerations that one ought to consider. So it's the same person, whether it's an individual or not. The effect of what is happening with the inquiry that's going to take place into the SABC will invariably require his participation. It will require that he gives evidence, and as I pointed out, there is a subpoena out for him, a subpoena in which he's been asked to produce documents. If he doesn't, the subpoena says that he's liable to go to jail. He would be criminal liable, and would say that that's sufficient to give him an interest in bringing the application.
I have no doubt that he has an interest in these proceedings, but to the extent that he can stop this hearing.
That's why we're here.
Yes,
I
want to hear you.
That he can do
I want
so.
to hear you on that.
Thank you, my lord. My lord, a member of the public who appears before a portfolio committee or an ad hoc committee or a committee of parliament, any of the committees, to give evidence under oath or affirmation expects to be treated with dignity. That's an expectation that a member who has been asked to come before a committee to give evidence under oath expects.
Well, that's a double barrel point, the question of dignity, because what do you say, that the summons has compromised his dignity?
No,
is that your argument?
That's why it's important to probably bear with me as I try to develop my argument, because as I develop the argument, it will be clear why dignity is very important, why the expectation of the public for when they appear before a committee that is asking serious questions about the governance of a national entity, that person expects, and the public expects, that the members that preside in that particular ad hoc committee treat that individual with dignity. That is not a difficult proposition, my lord. That it's uncontroversial. When I appear before your lordship, I expect to be treated with dignity.
I'll do so with absolutely.
And I'm grateful for
treated
that.
with the greatest dignity.
Yes, and that's exactly
but
what
what
we're saying.
concerns me is you've got to be objective about this. Is what, when a board as important as this has disintegrated to the extent that it has,
Can I
to be the last man standing is hardly very dignified position.
Can I develop the argument?
Yes, please.
So that
Please.
Your Lordship gets the comfort of what the chairperson of the
Yes.
applicant is trying to present to the court. So, a member of the public appearing before a committee of parliament must have the assurance that the members of the committee will not be influenced by their partisan political interests when they deliberate on the evidence that he presents. They expects that when he has given the evidence before the committee, that the committee will, with an impartial mind,
Yes,
with
but
a fair mind.
you see that impartiality permeates your argument, but we're dealing here with political parties. Political parties have expressed a point of view. Each political party in Parliament has a view on the SABC board. We must have the committee that hears this must be a committee of Parliament. So inevitably they'll have a view on the crumbling of the SABC crumbling. Do you take all of them out of the pot?
So what I'm really appealing to Your Lordship is for Your Lordship to allow me to develop the argument because the question you've asked is exactly the basis on which we've come to the court, and I do want to develop this question, the theory of the case well enough for us to feel that the court has now gotten the benefit of a full argument on the matter in the limited time that we have.
Now, please, you can take as much time as you want.
I have 30 minutes.
If I interrupt, you can take longer.
Yes, thank you.
The point to make, I have read your papers, so I have some idea of what your argument is all about. But this impartiality argument concerns me. You know, I know it's the basis of your argument. That's why I'm trying to get you to persuade me that I'm wrong.
And that's what I'm trying to do, my lord, but you interrupt me before I even try.
Please take your time.
Yes, thank you. So this is the issue, my lord. Any person who appears before a portfolio committee, any person who appears before a committee of parliament has certain expectations. He has expectations that when they appear before the portfolio committee and gives the evidence that is expected to give, that the portfolio committee members will not be influenced by any other issues than the evidence itself, that they will apply their minds to the issues with dignity and with independence and with impartiality. Now, it is an expectation that is born out of what our constitution says about the work of adjudicated bodies like the one that we're talking about, the ad hoc committee, which we say performs an adjudicative function. And that comes from our reading of section 15(1)(b) of the Broadcasting Act, which specifically says that and perhaps I should refer to that act, my lord, so that I don't summarize it unfairly and miss the very point that I need to make on the issue. 15(1)(b) of the Broadcasting Act says the appointing body must remove a member from office after a finding to that effect by a committee of the National Assembly and the adoption by the National Assembly of a resolution calling for that member's removal from office in terms of section 15A.
But does the National Assembly have a choice once a finding is put to it?
Yes, but see, the problem is we're dealing with the ad hoc committee.
Yes, what I'm asking you is, if the ad hoc committee makes a finding and it refers it to the National Assembly, does the National Assembly have the right to reject it, or must he adopt it?
No, the National Assembly has a discretion. They can adopt it. They can remember they vote. They don't have to.
Yes.
They vote. And
so
they will vote
the final arbiter, the final adjudicating forum is the National Assembly.
That's fair enough. But what should the National Assembly have before it?
But doesn't that gut your argument? Because the real decision is not made by the committee, but by Parliament itself.
No, my Lord, perhaps what the National Assembly is entitled to have before it, when it decides what to do about the issue on which whether to accept or reject the report, they're entitled to have a report of an ad hoc committee that has acted independently, that has acted impartially. We do not expect a National Assembly ad hoc committee to reflect exactly the same style of decision making as the National Assembly itself. Because the National Assembly, when the report comes to the National Assembly, it's a report. The members of Parliament, members of the National Assembly are not looking at how the witness performed when they gave evidence. They are not looking at what evidence was produced. All they're looking at is the report and the recommendation that they get. And the submission we make is that that report, which they look at, must be a product of a committee that is capable of applying its mind independently and impartially. In other words, when the National Assembly decides, for example, even with good evidence, the National Assembly may just reject the recommendation that the board be dissolved.
If I may interrupt you there, Mr. Masuku, is that committee not made up of different viewpoints, different political parties, and it will eventually reach an agreement on what its recommendation is?
As you know, my Lord, the committee itself is organized according to the representation of the political parties that are in Parliament.
Yes, but what I'm saying is that if you use the argument of that individual members may be biased, there will be different degrees of bias within that committee.
Yeah, I'm sure when the bench is sitting with 3 different judges, there is sometimes different degrees of expressing themselves on particular aspects.
No, but that's different. The bench is impartial to hearing a matter. Judges may discuss points of law that they differ on, or facts that they may differ on. But here, political parties are strident differently. They may have stridently different views.
But that's exactly what I'm trying to persuade your Lordship on. That the moment you say that it is okay for a ad hoc committee of a National Assembly to be biased because of the political nature of the Assembly, then we must accept, therefore, that it is part and parcel of our constitutional system that when an ad hoc committee is performing an adjudicative function, it must do so biased. We must just accept, and my client must walk in there accepting.
But that's the point that one of the people raised on the papers, I don't know which party.
No, but is that really consistent with our law? That a body that conducts an adjudicative function should, as one or two of the members of the respondents said, is it right? Is it consistent with the duties of an ad hoc committee that performs an adjudicative process, that sifts through the evidence, that looks through the evidence, that decides issues that may well affect the rights of individuals that are implicated? Is it correct to say, as a matter of course, because they are political in the work that they do, that when they sit in an adjudicative function, we must accept that political position will permeate how they reason.
If I may just interrupt you there for a minute, Mr. Masuku. Isn't that a decision to be made afterwards?
No,
to say after the hearing, look, it was so biased, they did not make a proper decision. Can you say that in advance, because there are conflicting views there, that the ad hoc committee was so biased as incapable of reaching a rational conclusion?
Yes, but
isn't it better, or would your argument be more logical to say, if its conclusion is so irrational that you take it on review at that stage, that it fails to comply with the principle of legality? But can you say in advance now that its decision is going to be so biased because they have these different views within the committee?
Yes, I do say that's a proper route to follow. Remember that we are setting
is a proper route to stop them from discussing.
Yes,
that's what you say.
That's what we submit. So what I'm submitting, my Lord, is that you don't have to wait until the violation of your right is perfected in order to approach a court for an appropriate order. Section 38 of the Constitution gives you the right to approach a court where your rights are threatened. What we have here, my lord, the best evidence of bias comes from the affidavit of the 10th and the 11th respondents who are going to be sitting in the committee. In fact, if one looks at page 101 of the papers, paragraph 6, this is what they say.
Page?
Page 101. Paragraph 6. In order to found this relief, the applicant complains that I, Honorable Van Damme, Mr. Walters, the other member of the third respondent.
In Parliament, they call them honourable. You don't have to call them honourable.
I just want to call them honourable. She's here, so
no,
I think we share.
That's a parliamentary courtesy.
Yes.
Okay, that's the sideshow, Mister. You can call them whatever you wish, Mister.
And then they say, in order to found this relief, the applicant complains that I, Mr. Walters, the other members of the third respondent, the ad hoc committee, and the parties they represent are biased because they believe the SABC board under Mr. Maguvhe leadership has failed dismally, and that the board should be dissolved and replaced by independent, impartial, and objective individuals. We have several responses to this contention. The first contention, I confirm that I, Mr. Walters, and the DA currently hold that view. So what view do they hold? The view they hold is that the SABC board under Mr. Maguvhe's leadership has failed dismally, and that the board should be dissolved and replaced. That's an issue that is still before this portfolio committee. They must still decide that issue. That's why they've invited evidence to be presented before them, so that they're able to engage with that evidence and come to the conclusion that these respondents here have come to.
But Mr. Masuku, they held this view at the earlier stage, but they were unable to convince the committee at that stage to proceed with an ad hoc committee. That came afterwards. So although they held that view, there wasn't a decisive view at some stage. Wouldn't it also be the subject of debate in the ad hoc committee, whatever view they hold? Or on the other hand, they could be convinced by the other members of the committee not to hold that view. I mean, that's the point of having not a judge deciding, but a group of people deciding what the correct position is in the interest of the country, I suppose.
Well, but my argument doesn't go far. If the court takes the approach that says that we have to accept that members of the National Assembly who are appointed to the ad hoc committee are entitled to prejudge an issue that is the basis of an inquiry that has been established, then of course, I mean, the whole application would fail. Because what must say
is a loaded word. I mean, they've expressed the view.
No, it's prejudgment, my lord. When you say that the SABC board under this leadership has failed dismally, and that the board should be dissolved and replaced by independent individuals, and you say we currently hold this view, if you are the person to appear before these particular individuals, you are already stuffed. There's no way you can walk into a committee of persons who hold this view and expect that they are going to be independent in the way they assess your own evidence and in the way they assess the performance of your performance in giving that evidence. They've already held that view. All I'm saying is that...
Can I, Mr. Masuku, just for my own edification, you don't expect the same degree of independence from a member of this ad hoc committee or a politician as you'd expect from a judicial officer.
But I asked the question why.
So is it your argument that a member of this ad hoc committee must display the same degree of impartiality as a judge or a judicial officer does?
I don't put them in the same league, but I'm saying...
But insofar as impartiality is concerned,
yes.
Do you expect the same degree of impartiality?
I think I'm entitled to expect that. I'm entitled to expect that. I mean, otherwise, what do we have? The members of the National
Don't
Assembly.
you, if that is correct, then you stultify Parliament.
Why would Parliament
Because
be
then
stultified by a
parliamentarians
requirement?
I mean, you'll be running to court each time to say any ad hoc committee, these people have their own point
No,
of
but
view.
that's not
The ANC has expressed the view, therefore every member of the ANC is be hostile to the DA or any other political party.
But as I say, if you proceed from the premise that our constitution allows for an adjudicative body to have a certain degree of bias, to tolerate a certain degree of bias against the parties that must still give evidence before them, then of course, I mean, I can't argue with that. If that's the view that the court holds, then that's the view the court holds. We submit that the constitution requires that where a party appears before an ad hoc committee of Parliament to give evidence under oath that relates to a matter of some importance, that party should expect that the people that that constitute that particular ad hoc committee perform their functions with a commendable degree of independence. I would perhaps reluctantly concede
Now, can you determine the lack of independence? No, not the lack of independence, that they will fulfill the function independently or impartially. Can you anticipate that?
When they have made when they make these comments prior to the committee or the inquiry sitting, when they make public comments, that I, as a party who's going to appear before them, that I hear them, I hear these comments.
Yeah, but could it be realistic, Mr. Masuku? I mean, politicians express themselves strongly.
My lord, I
if
say,
you don't, if you don't want to, you'll have to accept that as the real situation.
it's a frightening proposition, my lord,
Sorry?
to me.
It's a frightening.
Yes, it is a frightening proposition that you are telling the public that when they appear before a portfolio committee where it performs an adjudicative function, that they can expect to be treated with a partial mind. It's a proposition I wouldn't want the court to actually endorse. They are not entitled, when they sit in an adjudicative function, to prejudge a matter that is the subject of that inquiry. They are not entitled to make pronouncements.
Is it not an inquisitorial function that they
Even if it's an inquisitorial function, my lord.
Well, it makes a difference between whether it's inquisitorial and executive function.
Where a member
In law,
says,
there's a difference.
you see, when you are performing an inquisitorial function, there's a higher requirement of impartiality, because you have to ensure that you get evidence that supports me and that supports the other side. You have to be completely impartial when you are being in an inquisitorial environment. And so I say, if you are in an inquisitorial environment and you've expressed the views that are contained in the affidavits of the 10th and 11th respondent, it's a frightening committee to appear before, because that committee...
Mr. Masuku, many will hold the view that impartiality is a bourgeois myth.
I'm glad that the committee, actually the committee is not, the committee itself doesn't think so. Because remember, the committee, in the PCC, when the issue of recusal was raised, they accepted that there may well be a point about bias here, and they tried to reconstitute it. They accepted that proposition that perhaps we have gone overboard to actually express ourselves on certain matters. The only people who didn't see that point are the persons that 10th and 11th, who decided it doesn't matter, their points are their points, they will go into the committee and until they're persuaded differently, this is the point they hold. And I say, it's not right to expect members of the public to appear before a portfolio committee where that portfolio committee has said something like this. The board is politically compromised. The board is not complying with its fiduciary duties. The board has failed the SABC. The board has poor leadership. The board has acknowledged that it has failed in its duties. There was political interference during the interviews of the board. You failed us. The board wants to project cloud. The board is ineffective and lousy. That's before the inquiry. And the purpose of the inquiry...
But after that, the board failed to exist.
No, that's a different... You see, my lord, when you are faced with the kind of pressure the public comments that were made about the board, it takes my client to stand and to stand firm on what he believes his fiduciary duties entail. Some people do not take kindly to the kind of language that has been used in order to describe the board and its failures. So one shouldn't.
I mean, they do not take kindly to the language.
No, in the sense that they wouldn't have the courage to every day read in the papers that this is what they say, this is what is said about the board of which they are members. They've got, some of them have families, and they would want to see their names associated with something good.
But you know, that's part of life in contemporary South Africa.
So so all I'm asking this court to consider.
No, but if one is placed, I can understand your argument that people would not want to be publicly criticized, but when one is in a public position, then criticism where you fail is inevitable.
Now, I did not put it as far as you have, my lord. I did not say that.
No, but if you're the chairperson of the SABC, which is a significant position in the life of this country, in the continuing life of this country, then you can't be unduly sensitive.
No, but
especially if look at the objective fact here is the board has crumbled. It's crumbled to the extent that it's no longer quoted. That one can't logically argue that it still exists. But it doesn't mean that you wipe it off. You follow due process. That's legality. The legality here means that the Committee of Parliament decides, then makes a recommendation.
Decides what?
What you're trying to do is to subvert, in effect, the principle of legality.
No, that is not the argument that I'm making, my lord. And if I've made that argument, then I've been incoherent in my argument. I have not made the argument that this applicant here does not want a.
So, but which committee must? If this committee is biased, then which committee? Every body on that board would be, to some extent, compromised. No. They've expressed the view.
No, but with respect, Pericles, can I correct what you just put to me about the submission that you say I've made? I've not made the submission that the applicant wants to subvert the principle of legality. What he wants to uphold actually is the principle of legality.
It's following what I'm putting to you. That's the logical outcome.
It is not, my lord, with respect. Here is the applicant says, I want to appear before a committee. I want to appear before a committee of independent people.
Now, where will you find such independent people?
Well, your lordship's position allows for a situation where you say to Parliament, find people who can act independently and fairly.
They'll have to be outside of Parliament.
No, I don't know where that will come from. The duty of Parliament is to ensure that when they decide on this inquiry, when they conduct this inquiry, they do so in a manner that is impartial and independent. If your lordship says that is not possible, then I say, well, then legality is not possible, because you are essentially forcing members of the public to go before a committee on the presumption of partiality. I must just go before the committee or the other committee, presuming their partiality. If they don't like me, then that's fine.
No,
they don't like me.
But let's listen to that. If they do not like you, after hearing all sorts of witnesses, then they make a recommendation to Parliament. The matter is tabled in Parliament, is debated in Parliament, and then adopted or rejected. So it follows a logical course before it becomes a de facto situation.
You see, but as I said at the beginning.
Yeah, and also there may be a step in between. You may review that decision of the ad hoc committee.
There is an important aspect your lordship must consider. When Parliament or when the National Assembly considers the report of the ad hoc committee, it must be that it must weigh heavily on the minds of members of Parliament that the report that they are considering is not a politically driven report. but it is a report that is cooked out of a mind that is impartial and independent. When they exercise their own political vote, if you want to call it that way, or if I could call it that way, if they exercise their own decisions on what to do with the report, the comfort they must have is that what they're holding in their hands represents an impartial mind. We can't say that about portfolio committee as it's currently constituted. We cannot say of the ad hoc committee, I beg your pardon, of the ad hoc committee. We cannot say that. We cannot say that because we know the system that functions in Parliament is such that members of Parliament vote in accordance with in fact, the decision-making process of that committee is by vote. And you will see the constitution of that committee has got more, is represented in terms of representation in Parliament. So that means that if the ANC members decide, no, well, you know what, we don't want to take the rough position of having to dissolve a board, we'll take the more responsible position of appointing members to replace those that have left. And they decide, no, they're not going to do it. Then because they are voting, they will succeed. And I'm saying that is exactly what happens when the matter goes before the National Assembly. The National Assembly will, the vote of the vote that will produce that report is going to be the vote that's reflected in the National Assembly, because of the political composition of the nation. And I'm by no means suggesting that members of the Parliament are incapable of being impartial. I'm not suggesting that, because when they do disciplinary cases, they do exercise their impartial mind over their own colleagues, so they are capable of being impartial. What I say is that where the atmosphere of fairness, the atmosphere of impartiality has been polluted by public comments made regarding specific issues affecting an important institution like the SABC, it's important. It is so important for the public to be assured that those that are going to conduct the inquiry of an important institution have an independent mind. They are impartial. They are not going to be driven by what the 10th and 11th respondent are driven by, political loyalty of the position that they've taken. That's all that we're asking for. The applicant is not saying that the board should, a committee should not be constituted.
But what happens to the next step when the Parliament decides, and members of the National Assembly decide, are they then completely impartial?
No, but the National Assembly doesn't have to be impartial. That I accept. That must be accepted. But I say...
But that body, the National Assembly, ultimately decides this matter.
No.
All the subcommittee does, or the ad hoc committee does, it makes a recommendation. It's their view. It's not just the debated view.
It's not just a recommendation.
It's their opinion.
It's not just a recommendation they make. They make findings.
Yeah, make a finding.
Yes.
But the finding is subject to adoption by the National Assembly, and adoption subsequent to following proper debate, if need be.
My Lord, I do accept that you may well reach the conclusion that our constitutional system must accept, our constitutional system supports a position where the public must know that when they are summoned to come to Parliament, or portfolio committee, to appear and to give evidence on specific matters that are subject of an inquiry in terms of a separate legislation, that they will be faced with an impartial, with a partial ad hoc committee. That's the finding one must make. That whenever you are invited to come and give evidence before an ad hoc committee of members of Parliament, you inherently must accept that they are partial. Live with it. That's what we're asking. But that's not consistent.
No.
That's not consistent with the constitutional rights that Parliament must uphold. When they deal with individuals that are giving evidence before them on which negative or adverse findings may be made, Parliament has a duty to be sensitive to those rights. And that is why we say Section 34 is applicable. The right that this applicant has is the right to appear before a committee that is independent and impartial. Whatever those terms mean, they do not mean what we see here, where members of the portfolio, some members of the portfolio committee or other committee have expressed themselves in ways that that's inimical to the idea of an independent and impartial mind. This individual will walk in before that committee knowing exactly what Ms. Van Damme and Mr. Walters think about the board and his work in the board. He knows that already. How can he expect to get fairness and justice before a committee of members like that? And it is not part of our constitutional system to promote a conduct of parliament, of members of parliament, where people must just accept that there is partiality in the manner, in the way they deal with issues. And I accept the argument that if this ad hoc committee deals with issues, it goes to the National Assembly. Yes, it does. And one should not expect the National Assembly to members of the National Assembly to be restrained in how they express themselves over a report. But one must expect that when I give evidence under oath, and when I appear before an inquiry whose purpose is to make certain findings that may impact on the work that I was doing, that panel be impartial. Take an example, my Lord. An example of, say, of a judge who's being impeached. And I go there because it's very close to home. If that judge appeared before a committee of members of parliament who had already expressed their views on the guilt or the innocence of that judge, he would never feel that that committee is well suited to deal with the issues that they have to deal with. As you know, that is what happens in the process of disciplining judges. At some point, they must appear before before Parliament when they are being impeached, and the assurance that they must get
that fortunately hasn't happened yet.
Yes, no, we're glad about that too. Mm. But what I submit, my Lord, is that it is very important. It is almost the Parliament is also bound by Section 7.2 of the Constitution, I think 7.2 or 3, which says that they must uphold, protect, promote, and advance constitutional rights. They are implicated when a member is subpoenaed to appear before them. They are implicated where the purpose of the inquiry is to make findings that may well be adversely affect the individual concerned. So we would urge Your Lordship not to encourage Parliament to see their role where they perform an adjudicative function. We don't mind when they perform a legislative function. It is their job to be different, to express themselves however they wish when they perform a legislative function. But where they are asked to judge somebody, where they are asked to pronounce on the guilt or innocence of somebody, the duty is indispensable.
But
they
they're
must
not,
be
they're
independent.
Not, but are they in this instance determining the guilt or innocence of somebody?
Essentially, they are. If one let's go to the.
They're trying to determine whether the SABC is dysfunctional or not. Isn't that
perhaps
what
we should go there, my Lord. Just
look at the terms of reference.
Yes.
The terms of reference are preeminently issues which warrant urgent and careful attention in the national interest.
Firstly,
it's not determining the guilt or innocence, whether the chairperson did his job properly or not. They're simply going to decide whether the public perception is correct or not, that the SABC is dysfunctional, full stop.
I hear what Your Lordship is saying. But
so you were telling me that the hearing is something else.
Let's go to the
charge sheet.
Not the charge sheet. I'll run away from the charge sheet.
I thought you'd refer to it as the charge sheet.
No, I do. No, the act under which they.
The SABC Act.
Yes, not the Broadcasting Act.
SABC Act.
If one looks at the sections that we're dealing with.
I don't have the act before me, so you'll have to read it out.
Yes, madam. So this is what this is the it's a section 15A inquiry, section A 1B. So it says the National Assembly may, after due inquiry and by the adoption of a resolution, recommend the dissolution of the board.
Just get the supervisor, give me that piece of the act. Oh yeah, they got one. Yeah, yes. Thank you. Always ever handing this up. So the Broadcasting Act 1 to 25. What section of the Broadcasting?
Section 15(1)(b).
15(1)(b).
It says the National Assembly may, after due inquiry and by the adoption of a resolution, recommend the dissolution of the board if it fails in any or all of the following: discharging its fiduciary duties, adhering to the charter, carrying out its duties as contemplated in section 1311. Those are when one of the most important issues any director of any company concerns themselves with is the discharge of their fiduciary duties. If it's found that you've failed to discharge your fiduciary duties, that's a serious finding. One that may
that's one of the reasons upon which a board may be dissolved.
Yes, I accept that, my lord, but I'm saying
but
when you
that's not simply the only decision
yes.
which the ad hoc committee is to make.
And
but you see, I see you refer me to the board. 13(1) of the board talks about 12 non-executive members. Now, they don't exist anymore.
I can't take that argument further, my lord. You put that proposition to me many times.
Yes, but I didn't know about the 12. I mean, I looked at the act that's been handed up to me.
Yes. And I have said, my lord, that Parliament is actually responsible for filling the vacancies. And they haven't done that.
No, the President appoints them.
No, sorry, Parliament recommends to the President, and
yes.
Parliament has not done that. And of course, that makes it difficult for the board to be fully functional when Parliament doesn't want to.
So you are now I'm not saying you're apportioning blame, but you're suggesting that the board is dysfunctional because the state hasn't appointed the 12 members.
All I'm saying is let's not make too much of an issue that the board is not functioning. Because if the board is not functioning, the solution can be found. And that solution would include the Parliament appointing or recommending replacement members of the board.
Yes, but that's...
that would be a solution that's quite easy actually to do. But what Parliament has chosen to do, or what the National Assembly has chosen to do, is to actually conduct an inquiry, which they are authorized to do in terms of the Broadcasting Act. And in doing so,
that's a simplistic way of looking at it, because the reality is, I don't want to sound like Donald Trump there, but in this instance, the board members resigned in rapid succession, but the result being that your client is the last man standing of the non-executive directors.
What I can only say, my lord,
it's not a situation where a board member died and the Parliament appoints somebody else.
I understand what your lordship is putting to me.
One is seeing not simply a vacancy, but one sees the crumbling, the disintegration of the board itself. That's the consequence is what we see today with your client still there.
I understand that, my lord. All I say about that is...
No, but doesn't that give rise to serious concern?
No, my point, the point that I'm making, is that it does give rise to serious concerns. It does give rise, it does give a basis for the National Assembly to activate its the processes that they must activate in order to deal with that problem. But what the applicant is entitled to is to appear before an ad hoc committee of members who have not expressed themselves in a manner that gives the impression that they are biased and that they've already prejudged the issues on which this inquiry must be done. Perhaps let me make this very, very, very clear as something that should not be concerning anybody. An inquiry is necessary. That is clear from a number of issues that Parliament has raised. All that we're saying is that when that inquiry is being conducted with the purpose of making findings, that inquiry be an inquiry that is capable of operating independently and impartially. That's how narrow our argument is. It's got nothing to do with the fact that
now just tell me, just take that argument further. Once you concede there's an inquiry, who will constitute that inquiry?
No, but that's not for us. Perhaps
the Parliament elected to appoint proportionally people. I mean, political parties appointed their own people. Now, what do you say? How should this board be? How do we find 12 good and honest men and women, or whatever the number is here?
Well, let's put it this way. You know, partially sometimes it's not an issue of dishonesty. It's really that people have preconceived views on certain matters. Let me put it this way, my lord.
So, is it your suggestion? I'm sorry to interrupt you, Mr. Masuku, but is it your view that the ad hoc committee should take place, should consist of parliamentarians, but not these 12 parliamentarians or 18 parliamentarians?
All I ask is for the parliamentarians that constitute the ad hoc committee to be parliamentarians who are capable of being independent and impartial.
Yeah,
at the very least, we've got the 10th and the 11th respondent having expressed very strong views. No, actually, they've expressed findings in their.
Let's assume that's correct, but their political party is entitled to have representation on this ad hoc committee.
In terms of.
Now, if they appoint, instead of X and Y, they appoint V and W to the board, wouldn't they also have to express the same views of their own political party?
Perhaps that's where we would end up. We must therefore, in the proposition you're putting to me, my lord, accept that as a matter of course there is a presumption of partiality when one appears before another committee. That is the law, and that everybody everyone who appears before another committee of parliament, which is set up to make findings, must accept as a matter of law that that portfolio committee is not partial, is not independent.
But wouldn't one also, whatever views they've expressed, wouldn't one expect the parliamentarian to exercise his views independently once he sits on that committee?
No, my lord, when you know,
it's you see what you rely on, where you if I may put to you kindly, sir, where you're confusing is the court of law with its perception of bias. A court has to recuse itself. It's different when we're dealing with the early of democratic parliaments, participatory democracy, parliamentarians expressing their point of view. And once they're appointed to a committee, one expects them to exercise their functions independently and debate, engage their, hear the evidence, engage their colleagues in debate. And if they do not do so, then they compromise the political legality, and you can bring them on review.
No, but that's, you see,
what you're trying to do is you have a perception of impartiality, so you want to stop them from hearing the hearing, from participating.
It would apply in any environment where a party is called upon to give evidence. If the party called upon to give evidence before that body were to hear in the public domain that members who are going to make a decision on the evidence that they are going to give have expressed themselves on what they think about the issues in a way that just makes it difficult for the person to expect the impartiality from them. They're entitled to raise that issue in any body. Even I would go as far as saying that it would be proper for the public to be assured that when members of the public participate in the processes of parliament, including the adjudicative process of parliament, that they expect an impartial mind to be brought to bear on matters that are subject of that inquiry. That is for us a very important aspect. But can I be fair? Because it's important that we're not seen as people trying to run away from an inquiry or trying to forestall the inquiry. In fairness to the applicant, when the issue was brought to him and he was given the notification of this inquiry, what he did was to write to the chairperson of the portfolio committee, raise the issues. And the chairperson of the ad hoc committee, the chairperson of the ad hoc committee responded, and that response, my lord, is in page 36 of the papers. It's very important for our case what the chairperson of the ad hoc committee actually said. So and I must say that the response was a dignified response. It was a response of someone that you feel that you are being handled with a level of dignity. This is what the chairperson says. He says you are reminded that in
Is
paragraph
it page
1.1
36 is a...
No, 37, madam.
37.
It's annexed to MM.
Yes, I've got that.
He says in paragraph 1.1, you are reminded that the ad hoc committee on the SABC inquiry was established by a National Assembly resolution. The committee's terms of reference is outlined in the National Assembly motion, which was passed on the 3rd of November. The committee is not an extension of the portfolio committee or on communications, but an entirely separate committee. So he's assuring this particular applicant that don't see us as an extension of the portfolio committee because you nest views about portfolio committee. Then he says your request that a separate committee comprising individuals who are not members of parliament should therefore be addressed to the Speaker of the National Assembly for consideration. He doesn't say it's legally impossible to do so. He doesn't say that it is not consistent with our rules. He says address a letter, address your concerns, that a separate committee comprising of individuals.
That simply means that he can't make the decision or something like that.
I didn't hear that.
It simply means he can't make a decision on that.
Yes, but he is directing me to somebody he believes he can make a decision. Remember, I'm not a member of parliament.
No, he's not. That doesn't follow. I mean, he said, I don't know, make that decision. You speak to the Speaker about that.
Yes, but my lord, that's the advice he gives me. So I go to the Speaker. It doesn't say it's impossible.
Okay.
And it says in
but
two
now,
places.
on your knowledge, you have greater knowledge than the chairman. We all have. Of the Constitution. Is there another provision for outsiders to be part of a parliamentary subcommittee?
So my lord,
is there such a provision?
I don't know that there's a provision like that.
Well, I have no idea, yeah.
All I say, my lord, is that this is what the chairperson of the ad hoc committee says.
What he really says is, he didn't want to say you're talking nonsense. He says, okay, now please,
no, with respect,
take it to the chairman of the, take it to the Speaker of the National Assembly.
With
the
respect,
Speaker has a team of lawyers advising us.
With
the
respect,
sort of
my lord,
answer you'd expect.
With respect, my lord, he was more decent by. He was actually quite sensitive.
Yes.
To the issue. He paid attention to the role that he plays as an adjudicator and the chairperson of the portfolio committee. He did not treat this individual with disrespect.
Yeah, but it doesn't follow.
The suggestion that his statement means something different from what it says, it's just incorrect.
No, but it doesn't follow from that there is such a procedure.
Can I take it further to show you that this is not the only portion of the letter where he says take it to the National Assembly.
Yeah. No.
So if he was simply wanting to tell the chairperson that sorry, you're talking nonsense, as your lordship puts it, then this letter is not a letter that conveys that. This letter doesn't convey that.
Yeah.
This letter is a very decent letter.
Yeah, no, that's fine.
When the chairperson of the board engaged with it, he engaged with it decently because it was a decent letter. It was never conveying that kind of brush. And can I take it further?
But also, decency is one way of looking. He also did modestly. Modestly in the sense that I don't know, please.
No,
just go to the
he
Speaker.
understands, my lord, what his job is. Let's not belittle the response of the chairperson of that committee. He understands that as a chairperson of the committee.
Please, I'm not belittling him.
No, because the suggestion, my lord, with respect that he could have dealt with him harshly and he was just being modest, implies that this was something he had to dig from deep within. It comes naturally. He understands as a chairperson that when an inquiry is made about something as important as the independence and impartiality of the members, that's of concern to him. So he treats his subjects with dignity. That's all I'm saying. Let's not read what is not in the paper. This here.
I'm not reading anything is not there.
He doesn't say it's nonsense, my lord, with respect.
No, I didn't say it's nonsense. I'm saying he doesn't. That was not his response. His response was basically say, I don't know, but please speak to the Speaker.
No, that's not his response. The response is here. We've just read it, my lord. His response is address your request to the Speaker.
Yes.
That's what he says.
Yes.
He doesn't say, I don't know whether it's possible or anything. In fact, can I read somewhere else?
Yes, but does the Constitution make provision for such a hearing where there are non-assembly members who constitute the ad hoc committee?
My lord, I would like to argue that case at a different day because I do.
Is there such a provision?
I do say that if Parliament's role is not, if the role of Parliament has got different roles, the oversight role, and it conducts that oversight role in different ways, and the legislative function of Parliament. one of the things that Parliament does, which calls for a careful relook at how they constitute themselves, is this adjudicative responsibility, where they are asked, in terms of a different piece of legislation, to perform a function of adjudication. Our submission is that it has to be a committee of Parliament, and I say I will argue it on a different day, that point.
It has to be a committee of Parliament.
Because I'm saying to your Lordship that what you have now is a case that involves people who have already pronounced on the guilt of this individual. They have already. And I say guilt not because it's a misconduct hearing. Guilt in the sense that they will find that he has failed to discharge his fiduciary duties. But I'm very keen, my Lord, to read you this part of the Chairperson Committee, because
read.
Yes.
Please do that.
So he then 2.1, he says your concerns regarding the committee's composition are noted, but require further detailed elaboration. Appointments to National Assembly committees are made in line with National Assembly Rule 55. In terms of 155, political parties appoint members to represent them on committees and advise the Speaker accordingly. In light of the above, we are advised to bring the detail of all your concerns regarding the membership of the committee to the Speaker's attention. So he is not saying, he's not poo-pooing the request. He is not disregarding it. And then he goes on, he says in paragraph 4.1, in light of the above, as his conclusion, pending a different decision by the National Assembly and or the Speaker, the committee will continue with this business as per the decision taken on 3 November 2016. So what he's telling you is that, sorry, I can't do it. There has to be a different decision by the National Assembly or the Speaker on the aspect. Address your issues to him, to her. And then she will probably give direction to how the issues should be dealt with. But of course, when this letter was received, the next letter that came from Parliament, or the letters that came from Parliament on this matter was summons. The summons which are on page 39. Which means that the Speaker, who in fact instructed the Secretary of Parliament to issue these summons, had considered this request and didn't see it important to answer it, to respond to it, didn't give directions on it, even to say it is not possible to get what you want. A body of independent and impartial members who are going to engage with the evidence impartially and independently. So there is no response to this particular request that the body that has been established be relooked at. And I'm saying that is why I do want the chairperson of the ad hoc committee's letter understood correctly, because he was acting as someone who understands that as a chairperson of that committee, his members will act with impartiality and with independence. If there's a question around that, he would be concerned about it. And that is why he says there is a solution. And that solution is address all your concerns to the Speaker, who will then give directions on how we deal with it. But we know that that has not happened. What happens is that you get a summons that says produce documents, and of course, if you don't, you go to jail. And so we say, my Lord, it's important that we don't say to the public that it's okay for Parliament, when they perform an adjudicative function, to be biased. It's okay to express themselves the way that the 10th and the 11th respondent have expressed themselves, even on their affidavit. It's important for the court to say so, to say it's important that Parliament's committees that perform adjudicative functions do so independently and with a clear mind of what their tasks are. Because they have a duty to uphold the Constitution and the rights of people that appear before them.
Thank you. Is there anything further you wish to say, Mr.
Yes, there is something.
Let's move off the partiality point now. Let's hear some.
Sorry. Yes. My Lord, we have dealt with the issue relating to the summons itself. And as your Lordship would know,
I have read. I haven't read them yet.
We have.
I got them at lunchtime, so I haven't read them.
Yeah, I hope, my Lord, you do get an opportunity to read them, because it's very important that they are a very important aspect. we deal with the issue of summons in page 27 of our heads. My lord, let's start off, and I know that there is a bit of impatience about time, but
No, don't worry, but just complete your argument fully, let's.
No,
Let me be kind, fair to you at least.
My colleague here is giving me the eye. The summons, my lord, are in, as I said, page 39 of the record.
Yeah, I've seen the summons, yes.
And then you will see that at the back of the summons, it says failure to, at the bottom of page 40, it says failure to deliver the requested documents at the time and place specified above is an offence punishable upon conviction by a fine or imprisonment for a period not exceeding 12 months of both the fine and imprisonment. So there is a cohesive instrument that is used in order to ensure that people participate in this particular committee. But what we are told about these summons is that they are issued in terms of Section 14 of the Powers, Privileges, and Immunities of Parliament and Provincial Legislature Act, read with Section 36A. Perhaps, my lord, let's start off with Section 30, with Section 56 of the Constitution, 56A. Section 56A of the Constitution basically says the National Assembly and any of its committees may summon any person to appear before it to give evidence on oath or affirmation or to produce documents. You'll see that in the Constitution there is no the power to issue to summon any person is with the National Assembly or its committees. It's the National Assembly or its committees. That's in terms of the Constitution. So committees can from just the Constitution itself issue summons. But we know that if you go to the Powers, Privileges, and Immunities Act, Section 14. Section 14 says a joint committee, and a joint committee is in fact defined in that particular act. And a joint committee is, in terms of the definition, a committee consisting of members of both houses of parliament, the NCOP and the National Assembly. Yeah.
Yeah.
And it says and then it says the joint committee may summons any person to appear before it to produce, to give evidence and to produce documents. May require any person or institution to report to it. Then subsection 2 says a summons in terms of subsection 1 or section 56A or 69A of the Constitution to appear before a house or committee to give evidence, to produce documents, must be issued by the Secretary on the instructions of A, the Speaker or the Chairperson. So the Speaker, when you're appearing before the House, when you're appearing before the National Assembly, will be the one that is authorized to issue the summons. If you're appearing before the NCOP, the Chairperson will issue summons. Or subsection B, the Chairperson of the committee concerned, acting in accordance with a resolution of the committee and with the concurrence of the Speaker or the Chairperson. So these summons are summons that come from the Speaker and not the Chairperson of the ad hoc committee, who is authorized to actually issue those summons.
But isn't that dealt with in Section 56?
Section 56, my lord, do you perhaps have a constitution then?
I don't have it here. But, What does section 56 say?
But all that we say, actually, perhaps I should stand. I should be fair to the.
You see, in section 56 says, the National Assembly or any of its committees may, paragraph C, compel, in terms of the national legislation or the rules and orders, any person or institution to comply with the summons or requirement in terms of paragraph A or B.
Yes.
So it means that not only the National Assembly, but any of its committees may compel, in terms of national rule, any person or institution to comply with the summons.
That's true, and we accept that. But what has happened here is that it is not a committee or the National Assembly or the National Assembly that has issued the summons.
But isn't this a committee of the National Assembly?
No, that's why, my lord, you see, these summons are not issued by the chairperson of the ad hoc committee, who in terms of the Act is entitled to do so. If one looks at section 14,
so is this Mr. on the instruction of the National Assembly?
yes. So
it's done on the instruction of the Honourable Mbulaheni Maguvhe MP.
Those are the summons, and we say that that's not regular, that's not lawful for the Speaker to issue summons.
But let's go back to section 56 then. 56 says, the National Assembly of any its committee may. So the Speaker speaks on behalf of the National Assembly.
That's correct, my lord.
So this is Mr. Magidlana, who signed this, was acting on instructions of the Speaker.
Yes, but let's go back to the.
So I can't understand your problem in this regard.
Okay, but that's why perhaps we start off with the summons themselves.
Yes, I'm looking at the summons.
Yes, the summons are issued
by the Secretary of
Parliament.
But on instructions of the Speaker, which is the Speaker of the representative of the National Assembly.
That's correct. And it says acting in accordance with the resolution of the National Assembly.
Yes.
Adopted on the 3rd of
November. It appears to be correct on the face of it.
It's not correct, my lord.
Why I don't follow you. Why say it's not correct?
It is not correct because the summons are issued in terms of section 14 of the powers and privileges and the Immunities Act.
Yes, but it's the...
Can we go there first? Because that's where the document, when it comes to the applicant, tells the applicant that these summons have got legal authority. That legal authority comes from these provisions of the Act. One looks at the provisions of the Act.
But it says, but the summons says, powers and privileges and immunities of Parliament, Provincial Legislation Act, etc., read with section 56A of the Constitution. Section 56 of the Constitution simply says the National Assembly or any of its committees may summon any person to appear before it or to give evidence, an oath or affirmation, or to produce documents. Now, this summons appears to be pursuant to that.
Can I perhaps take you, my lord, to page 27, paragraph 51 of our heads of arguments?
Of your heads of argument.
Yes.
Let's see.
We bring clarity to the issue in that portion of the. Am I correct? So we say it is common cause that the impugned summons were issued by the Secretary of Parliament on the instruction of the Speaker. When you look at the summons, at the second page of the summons, it says that the Speaker gave the Secretary instructions, and she was acting in accordance with the resolution of the National Assembly. In the resolution of the National Assembly, which is reproduced as we have referred to it in the answering affidavit, the alleged resolution for the Speaker to instruct the Secretary of Parliament to issue summons is not there. There is nothing in the resolution that says that these summons derive their authority from that resolution in resolution that is referred to. Right, so given that it is common cause that the Speaker instructed the Secretary of Parliament to issue the summons, we submit, and the first to the third respondent submit that she was entitled to do so, and therefore that the summons is valid and must be complied with. What is left for this court to interpret is to interpret the relevant provisions of the Constitution and the Privileges Act to see if the Speaker had the power to do what she did. And we refer to the legislation there. Our interpretation starts at paragraph 54. And we say that the section 56A of the Constitution says what it says. The National Assembly or its committees may summon someone to appear before it, give evidence or reproduce documents. Similarly, section 69A says the same thing in respect of the National Council of Provinces. What is clear from these two provisions is that they give the National Assembly or its committees the power to summon any person to appear before it or to give evidence. What we say is that Section 14 of the Privileges Act, when Section 14 of the Privileges is interpreted, regard must be had to these provisions to which Section 14 itself refers. Now, one must always remember that Section 56A, in terms of Section 56A, a committee of the National Assembly may summon a person. It's a committee of the National Assembly may summon a person to appear before it, to give evidence. Similarly with the Committee of the National Council of Provinces. When you go to the Section 14 of the Privileges Act, that subsection provides that summons in terms of subsection 1 of Section 14 or Section 56A or Section 69A of the Constitution to appear before a Committee of Parliament must be issued by the Secretary on the instructions of the Speaker or the Chairperson. So if one is appearing before a committee, or let's put it this way, a committee of the National Assembly, a committee of the National Assembly itself, or the committee of the NCOP or the NCOP itself, the Speaker and the Chairperson of those entities may issue instructions. The Secretary may issue instructions.
So what is wrong with the summons? I still don't get you.
No, I think, my Lord, I have. What is wrong with the summons is that if one looks at the summons, they say they derive their powers from the Privileges Act, Section 14.
Is read with the relevant sections of the Constitution.
But when you go to the Privileges Act, my Lord, I would urge that you patiently look at the Act itself to see what the Act says about the power of the Chairperson of the ad hoc committee to issue summons. It is not, because this is an ad hoc committee. It is not it is a separate power to issue summons, and that is clear from Section 14(2) B of the Privileges Act. If one looks at it, it says, and my Lord, do you have that section?
Yes.
It says a summons in terms of subsection 1 or Section 56A or B or 69A of the Constitution to appear before a House or committee to give evidence or to produce documents must be issued by the Secretary on the instruction of the Speaker or the Chairperson, or the Chairperson of the committee concerned, acting in accordance with a resolution of the committee and the concurrence of the Speaker or the Chairperson. Now, if the intention was that the Speaker would issue or could give this summons, would authorize this summons, then he would not need to have the concurrence of the Speaker or the Chairperson.
Yeah, but this instance, what we have is, we have a summons, terms of regulation, Section 14(2) of the Privileges Act, and consistent with the Constitution, it's issued by the Secretary on the instructions of the Speaker of the House. That's what the first portion of the regulation says.
My Lord, the point that we make is that only if you're appearing before the House can the Speaker issue the summons.
No, it
And
says
only-
owed to appear before a House or a committee.
Yes, no, that a House or a committee of the National Assembly. Well, how does one interpret, my Lord, Section 14.2 B of the Privileges Act?
Well, given an option, it's either the Speaker or the Chairperson or the Chairperson of the committee. Everything is said in alternative.
But my Lord, we've made submissions in our heads of
I
arguments.
will read them again.
I'll stand
I will read them
on
again.
my heads of arguments, and perhaps my junior will deal with it in
Okay, good.
reply, because we appreciate that
You have
it's
overreached your
late
time.
in the day, and we've taken
Yes.
more than enough.
Yes.
So my Lord, we would persist with the relief that we seek.
Thank you, Mr. Masuku. Mr. Potgieter?
I think we've agreed that Mr. Jamie will
Mr.
follow.
Jamie
yes,
will follow.
and then I will follow.
Thank you. Mr. Jamie, let me get your heads.
Before this one, Judge, I don't intend.
Mr. Jamie, you subscribe to all the views expressed by Mr.
Not quite all, Judge.
Not quite.
No.
Firstly, on behalf of the SABC,
I act for the SABC. That's correct. Where else?
do you challenge the partiality of the committee?
Do we challenge the partiality
Yeah.
of the committee?
Yeah.
Well, with respect, Judge, the partiality of the committee is self-evident on the papers.
Yes.
And can I immediately indicate what our position is in that regard? We don't suggest that a committee of parliament must act as judges and have the same level of independence and impartiality that a judge would have. That is not the submission. It's a more nuanced submission. And perhaps I should begin with the passage.
Sorry, what do you say? It's more
Nuanced.
or more nuanced?
And perhaps I should begin with the passage, Judge, from a case, well-known case, Hamata and another v. Chairperson, Peninsula Technicon, which you'll be well familiar with the decision of this division by your brothers Schlope and erstwhile brother Brunt. The citation, it's not in our heads, the citation is 2000, volume 4, page 621C. And the passage is at
2000?
2000, volume 4, page 621C. And the relevant passage is 67. Where the learned judges say the following: it is our view that it is not bias per se to hold certain tentative views about a matter. It is human nature to have certain prima facie views on any subject. A line must be drawn, however, between mere predispositions or attitudes on the one hand and prejudgments on the issues to be decided on the other. Bias or partiality occurs when the tribunal approaches a case with its mind open, approaches a case not with its mind open to persuasion, nor conceding that exceptions could be made to its attitudes or opinions, but when it shuts its mind to any submissions made or evidence tendered in support of the case it has to decide. No one can fairly decide a case before him if he has already prejudged it. Thus, prejudgment of the issues to be decided, which is in a sense prejudice, constitutes bias. The entire proceedings become tainted with bias. Now, that is an accurate description
In that
of
case,
the legal...
what was it that made the decision? Which body?
I beg your pardon, Judge?
Which body made that decision?
The Peninsula Technicon, Internal Disciplinary Committee. So it was a disciplinary committee.
No, disciplinary committee.
That's correct. Now we
Was
subscribe...
I not chair of the disciplinary?
You may have been, Judge. I'm not sure.
I was
It's
chair
an
of council at about the same time.
I'm sure you wouldn't have associated yourself with anything.
I'd have been more
in the
impartial.
order of prejudgment, Judge. That is the legal positions, and our submission simply. And you asked me, do I agree with everything my learned friend Mr. Labata has said? We don't, for the simple reason that we don't suggest that no parliamentarian may sit on the committee where the political parties have expressed a view. So there's a distinction with the applicant. I believe.
Well, all the political parties must have expressed
Most
their
of the
view.
political parties have expressed the view. Our position, and we're not the principal contender in that dispute, but you have asked me what our position is. Our position, Judge, is that political parties may express views. Non-constat, that the people who sit in judgment, and I'm going to take you in a moment to the section.
But whoever sits in that committee, if he comes from a political, will echo in most instances the views of the political. But it doesn't mean that he or she won't be able to.
Then they would not be carrying out their functions because, Judge, there's a.
You know, accept that, but when they sit on the committee, they'll have to evaluate the evidence as it comes.
That's correct. They must evaluate the evidence before them. It would be totally improper and a subversion, to use your term, of the entire process, if the political parties were to dictate what the views and conclusions
that
of
must
the
be
members
correct.
should be.
The political parties can't dictate.
And Ms. Van Dam is well aware of that because she says that in her affidavit.
Yeah.
But the fact of the matter is, Ms. Van Dam, with the greatest respect to her, has approached the matter on the basis where she says, on affidavit, that this is my view. I've already reached the view that you are dysfunctional and your members are incompetent,
that
etc.
is her view. That view she expressed when she was serving on that committee.
It's more than a view expressed, Judge. It's the statement of a conclusion. And the difficulty with that is she has expressed her conclusion on the very matter which she must sit in judgment upon. Because the distinction between certain other situations where Parliament may have to carry out an oversight function and reach a conclusion which has a political element, such as where to demarcate the boundaries of a municipality, or some other politically charged matter, you can fully understand that the quorum rules would apply, you follow the party line. That can never be the situation where the requirement, as it is in section 15A(1)(b), is to reach conclusions of fact based on evidence. That is what this committee is charged with. And with the greatest respect, there are two parts in Ms. Van Dam's affidavit where she demonstrates that she doesn't understand, again with the greatest respect to her, that distinction. The one, Judge, is in paragraph 89 of the affidavit,
Page?
89, where she says the following. In the second sentence, or the third sentence rather of that paragraph, she says the following. Parliament is not a court, and its inquiry in terms of section 50.
Page 89 is
I'm sorry, para 89 on page 31 of the papers are not paginated, so it's a bit difficult. Judge.
My pages are paginated.
Your pages are. Then you have a significant advantage over me, Judge.
No, but which of her affidavit you say page
Her affidavit,
101?
paragraph 89,
It's
on
101, I
on
believe.
printed page 31.
Okay, yeah, okay, that's.
She says, Judge, in the middle of the paragraph, Parliament is not a court, and its inquiry in terms of section 15A(1)(b) of the Broadcasting Act is not a dispute that can be resolved by the application of law. Now, with the greatest respect to her, she's wrong. It is a political matter in the sense that it requires the National Assembly to exercise its oversight of the SABC in the best interests of all South Africans. Now, that last statement is a non sequitur from the earlier part of that sentence. Of course, the National Assembly must exercise its oversight of the SABC in the best interests of all South Africans. It doesn't follow from that it can convert a factual inquiry, which is what 15A(1)(b) deals with, an inquiry into fact, into a political exercise. You cannot decide questions of fact politically. That is a fundamental mistake on the part.
No, you don't say that.
That is precisely what she says.
All she says it is a political matter. But she doesn't say that it is not inquiry of fact.
Well, Judge, I'll take it a
And she
second.
takes it further and says, in a sense, it requires the National Assembly to exercise
Well,
oversight.
Judge, I'll take you to a second paragraph, where she
On the
makes
same
it.
paragraph?
Sorry.
On the next paragraph?
No, I tell you there were two paragraphs. The next
I
one is paragraph 120 on printed page 38.
Let me just see, this paragraph didn't say much.
In this paragraph,
One or two, you say?
she characterizes the inquiry as a political exercise, or political matter.
Yeah.
Then in paragraph 120 on page 38, Judge, she says the following, which makes, with respect, her position clear, the position of the DA. I deny that an inquiry in terms of section 15A is a dispute that can be resolved by the application of law, which is a paraphrase or a repeat of section 34 of the Constitution. That, and then she says, is an exercise that can be resolved by the application of law that requires a fair public hearing in terms of Section 34 of the Constitution. So her position is, it does not require a fair public hearing.
No. It denies it's a hearing.
That requires, she denies.
Which is Section 34 of the Constitution. Not as familiar.
You will know, Judge, well, you're reading the section now. Section 34 is titled Access to Court.
Access to court, all it says is, it's not she doesn't mean it not denies a fair public hearing, but denies a fair public hearing as contemplated in Section 34.
But now, what does Section 34 say? Section 34, despite having the heading Access to Courts, goes wider, as you know. It says, everyone has the right to have any dispute that can be resolved by the application of law, decided in a fair public hearing before a court, and this is then the important words, or where appropriate, another independent and impartial tribunal or forum. Now, Judge, I don't act for Mr. Maguvhe of the board, I act for the SABC. And I should have begun with stating to you what the SABC's interest in the matter, legal interests in this matter are. But the point I want to make at this stage is both the SABC and the board have the right to have matters of fact, which are in dispute, determined not only in a fair and impartial manner, but before a tribunal which is both independent and impartial, as required by Section 34 of the Constitution. And that's the hallmark, or that's the yardstick against which you're going to judge the conduct of the MPs concerned. And we say their conduct speaks for themselves, or itself rather. They've conducted themselves in a manner which...
All she says is she quotes the Section 34.
And she says it doesn't apply to her.
It doesn't apply.
Now...
You say Section 34 applies.
Well, more importantly, Judge, if she says Section 34 doesn't apply, she's saying that her ad hoc committee is not required to be an independent and impartial tribunal.
No.
She must be saying that.
No, she's not. That doesn't follow. All she's saying, she's quoting the Section 34 doesn't apply, and she quotes the Section.
But Section 34 applies, Judge,
yeah,
where there's a need for an independent and impartial forum. So Section 34 covers two scenarios.
Yeah.
One is, is there a dispute that can be decided by the application of law?
Yes, but Section 34 applies to, effectively to, as it says in its heading, access to courts. It applies to courts and tribunals. This is not a court or tribunal.
Judge, the word tribunal, I don't have my dictionary here, tribunal, but sorry, it's not in tribunal.
It says forum, yeah.
It also says forum. This is certainly a forum.
Yeah,
in the
forum comes from the...
In the true Roman sense of the word.
Senatus Publisque Forum.
Well, actually, not in the true Roman sense of the word, because forum was market.
Yeah.
Which, and maybe this is a marketplace of ideas, or marketplace of something, Judge, but what it isn't is a forum where impartiality and independence can be thrown out of the window on the...
Yeah, but it's also qualified, the Section 34 full stop. And she says it is an investigatory and legislative determination made in the best interest of the SABC by the National Assembly as the representative of the shareholder. Now, that must be correct.
No, Judge.
Why?
You see, let me take you Section 15 and just let's look at what we're dealing with. Section 15A1B. And we know this is a Section 15A1B inquiry because of the notice of the hearings, which refers to that section. You find it on page 31. So this is a 15A1B inquiry. Now, what does 15A1B deal with, Judge? It doesn't deal with political conclusions. It deals with the following. The National Assembly may...
Which section? Where is that 51B? Where do I find it?
15A1B. Sorry, Judge. We've handed you a bundle.
Yes.
It contains the Broadcasting Act. I think the first document. The first document is the Broadcasting Act. So you'll find it there, Judge. On page...
Oh, I see where it is. Yeah, I've got it. 51.
It's on page 16. So 15A1B, and this is the subject of this inquiry, does not deal, as was saying, with political decisions. It deals with the following. The National Assembly may, after due, and can I emphasise the words due inquiry? And we know what due means, Judge. Due means a proper, thorough inquiry, not a cursory inquiry, but a due inquiry. So may, after due inquiry, and by the adoption of a resolution, recommend the dissolution of the board if it fails in any or all of the following. So the first conclusion that there must be, and we all know this as lawyers, and maybe lay people wouldn't appreciate it as much, Judge, there must be a finding of the failure. Not a possible failure, but an actual failure. And then a failure in what? Discharging its fiduciary duties. There must be a finding of fact that the board has failed in discharging its fiduciary duties, or adhering to the charter, or carrying out its duties as contemplated in section 1311. Now 1311, which you will find across on the other column, says the board controls the affairs of the corporation and must protect matters referred to in section 6.2 of the Act. And section 6.2 of the Act, Judge, says that the authority must monitor and enforce compliance with the charter by the corporation. Now that is another question of fact. So those are three questions of fact which the committee must make a finding on. It can't make those findings of fact on the grounds of political expediency or what it thinks is in the best interest of all South Africans. It must make it on the basis of evidence that has been properly
assuming you're right on that.
And can I just, sorry, Judge.
The National Assembly, after due inquiry, makes the...
That's the other point where I disagree with my learned friend, Mr. Masuku.
But this is only the due inquiry.
No. The National Assembly
makes the decision.
The section, no. Can I just tease that out, Judge? The section refers to the National Assembly as, after due inquiry, and by the adoption of a resolution, recommend the dissolution of the board. The National Assembly consists of 400 and odd members. Clearly, the National Assembly can't conduct inquiry, can't sensibly conduct inquiry. Hence, it appoints a subcommittee, in this case, an ad hoc committee, to do it. But the ad hoc committee acts qua National Assembly. It is now the National Assembly.
But that's not correct.
It is correct.
That's not
the
correct.
National...
You see,
Judge,
when the National Assembly makes its decision, it does so...
No, I'm not saying that... Sorry.
It does so after the findings are,
I know, but
are presented to it.
Yes.
And it doesn't blindly accept it. It reads the report, it debates the report, and then 400 members make a decision.
But it has not had the benefit of hearing the evidence, evaluating the witnesses.
It must rely upon the inquiry.
What I'm saying, Judge, is when conducting the inquiry, the committee acts qua National Assembly. Only that. I'm not saying the committee gets to decide or make a recommendation. The National Assembly must make a recommendation to the appointing authority, which is the President. So you're correct. The National Assembly must adopt a resolution.
It makes the decision.
It makes the decision. It adopts the resolution.
Whether or not to proceed against the board or not.
Yes, but you cannot suggest, Judge, as I think you did with great respect to Mr. Masuku, that, well, because the National Assembly is making the decision, you've got another chance, and all your ducks are not sort of in one box, if that is not a horrible mixing of metaphor. The point, Judge, is that the National Assembly...
I'm trying to sort out the metaphor.
Judge,
okay, carry on. Now you're in
the point.
In the National Assembly.
The point is that the National Assembly must perforce rely on the due inquiry conducted by its committee, on whom it relies, and also relies upon the committee for its recommendation. So the National Assembly's decision is only as good as the work of the committee. That is clear. If the committee,
but the committee,
if the committee is fundamentally biased, the National Assembly may well be led into a position where it doesn't know that, and thus it acts on bias.
It's not the applicant's case that the whole committee is biased.
No.
It's the applicant, one or two members are biased.
Yes, but one or two members...
One or two members, even if they are biased, so what?
So what, Judge? I've read to you...
No, if it's not...
They may be very persuasive members, like you, Judge. In which event, in which event you may... The bad eggs may persuade the good eggs as to the bad eggs' bias and predisposition. So you can't say, and you are as well aware as anyone, Judge, of the fact.
Mr. Jamie, look at it in the real context. I'm using the word real too often, I should You just get another synonym for that. We're dealing with the parliamentary context. We're dealing with the political context of these events occurring. Political in the sense of governance. Are you going to ask every time the subcommittee, every member of the subcommittee has reflected bias or not?
No, Judge.
In any event, if they come from political parties, each of the political parties may or may not have expressed a view
But
which results in some perception of bias.
we know that, but I dealt with that at the outset. I said the mere fact that the ANC and the DA and the EFF have expressed such virulent views against the SABC and the board does not. We don't take it to that level to say, well,
But
that
the
excludes.
views are not virulent.
They're pretty virulent.
Sorry?
I say, well, maybe it's a question of opinion.
No, it's not the views that are virulent. The virulence seems to have seeped the board.
Judge, I'm not here to defend the board.
But I'm looking at the situation that it exists. This board no longer exists. Your governance no longer exists.
No, but Judge, that's why I said I'm not here for the board. I'm here for the SABC, and our interest is different.
But you see, you can't draw that distinction because the SABC's governance is lost.
No, but Judge, that doesn't mean that you throw the baby out of the bathwater. The fact of the matter is, the subject of this inquiry, you referred to
This is not the baby in the bathwater. There's the elephant in the bathwater. The entire board is as a baby means a small portion, I suppose. I'm also mixing metaphors, Mr. James. Please carry on.
Judge, you referred to the notification of the hearings, I think. That's at page 31, and if you go to page 32 of the papers.
32 of which papers?
Of the papers, so the application.
Ms. Van Dam's affidavit.
No, it's page 32, sorry, it's number 32, as in paginated 32, so it's annexure MM1 to the filing affidavit.
It starts with paragraph 91.
No, it's annexure MM1, Judge, to the filing affidavit, which I have as page 31. It's the first annexure. It's the terms of reference.
I'm looking at
So you don't have it, Judge?
I'll find MM1, MM7, MM6. Okay, I got MM1.
Page 31.
Yeah, it's the
Terms of
letter from
reference.
Mr. Smith.
Yeah. If you go to page 32, Judge, you'll see the terms of reference are dealt with, and they require, or rather, terms of reference are to inquire into the ability of the SABC board to discharge its fiduciary duties, including considering, and then it says the financial status and sustainability of the SABC, and secondly, the SABC's response to the Public Protector report when governance and ethics fail, to recent court judgments, and to the ruling by the Independent Communication Authority, ICASA, that the SABC should withdraw its decision to ban coverage of violent protests. So clearly, the subject matter of this inquiry is not only the conduct of the board, but also the conduct of the SABC, which is why we are interested in how this board conducts its business. So that's our first point of interest, Judge. Our second point of interest is the commercial sensitivity of certain of our documentation and information, and that you find dealt with on page 39 of the papers. It's not dealt with, but it's set out, and we refer to it in Mr. Aguma's affidavit. If you go to page 39, which is the summons, Judge, then what the board is being required to produce, or what Professor Maguvhe and Ms. Holdenes, in a capacity as the company secretary of the board, as well as the applicant, are required to produce, inter alia Judge C, minutes and transcripts of the subcommittee and board meetings relating to the following: consideration and approval of the multi-choice deal, the consideration and approval of the implementation plan, and then, sorry, what I
But that emerges from the public protector's report.
What I omitted to refer you to, Judge, is B. Minutes and transcripts of subcommittee and board meetings, if any, at which decisions to procure services from Sekela, Hasibu, PricewaterhouseCoopers and Vision View were taken. Now, those are all commercial transactions in which the SABC is a party, or to which the SABC is a party. What Mr. Guma says is that there are confidentiality aspects, Judge, and I don't think it's hard to imagine that in large matters involving many millions of rands, sponsorships, deals with multi-choice, etc., there would be confidentiality issues. The SABC has an interest in protecting information which is commercially sensitive and or confidential, which is our second point of interest in this inquiry. We want to be there, Judge, in order to, if people are asked to produce documents to which we can raise a valid legal objection, we want to be involved. And as you know from the papers, we were not even invited to participate in the inquiry. We wrote to the committee to ask them why we were not invited to participate. Those documents don't belong to the board.
But your chairman was there.
But he's distinct, Judge, to the SABC. He's the chairman of the board. The SABC has the proprietary interest and ownership of those documents, not the board.
Is that a real distinction?
It's a fundamental distinction, Judge.
Your chairman has access to all that.
The chairman is a non-executive chairperson of the board. He cannot control the day-to-day operations of the SABC. That is done by CEO and COO and CFO, Judge. Just get this provision that you showed before. So the board has oversight, authority and control of the SABC, but not its day-to-day operations. Its executives, and there are 4 of them, the chief executives. I'll give you the document which I think it's in our bundle, Judge, which specifies who those are. Sorry, the executive committee of the SABC runs the SABC. And the executive committee, you'll find it on page 16 of your bundle, which is, this is the, another one is this document. It's the Broadcasting Act, in fact, Judge. Section 14 deals with the executive committee of the SABC, and it says the affairs of the corporation are administered by an executive committee consisting of the group chief executive officer, chief operating officer, chief financial officer, and no more than 11 other members. The executive committee is accountable to the board, and the executive committee must perform such functions as may be determined by the board. But that doesn't detract from the fact that the executive committee is responsible for the affairs of the SABC, not the board. It must account to the board for how it carries those out, Judge. But there's a very real distinction.
All you have to do is go to the parliamentary ad hoc committee and ask to be represented.
And what if they refuse, Judge?
But then we come to court. They haven't refused.
And then we come to court, and
so look, we also want to be present.
And the proceedings continue in our absence. Can I, Judge? Just dealing with that. Can I?
What you're doing is you're placing obstacles.
No, we're not placing obstacles, Judge. And can I just deal pertinently, because there's very close.
You represent a corporation whose board is disintegrated.
Judge, no one is trying to.
Now you're saying that the corporation itself is not cited. Those are technical problems.
It's not technical.
It's technical in the sense because there's absolutely no reason why the executive can't give Professor Maguvhe the necessary documentation to present before the committee. You see, what we're getting is stonewalling.
With greatest respect, it's not coming from us, Judge.
Yes, sorry?
With greatest respect, it doesn't come from us. We're not stonewalling. We are complaining of not being invited.
You also, your clients, you are not you, Mr. Jamie, but your clients certainly are reluctant to let this, you are here to oppose the.
But Judge, how can you accuse us of that when we are complaining about not being invited? That's not the conduct of some stonewalling. We want to come to the party, not prevent the party from happening.
Yes, but You're saying that now?
I've said it all along. We say it in our papers. I'm not saying it now.
Yes, but why don't you just give the documents to Mr. Professor Maguvhe?
Because he's not entitled to the documents.
Sorry?
He's not entitled to the documents.
As chairman of the board?
Well, he's entitled to see the documents, but he's not entitled to present the documents.
Why not?
Because he's not the owner of the documents, Judge.
But he's the chairman of the board.
Yes, but this is a contract. If the relevant executive officials conclude a contract, it's not being technical, Judge, it's being fundamental.
I was chairman of council at the university, and I had every access to everything. I was the chief, what do you call that? The chairman of council, chairman of a board, even though non-executive, is entitled to, he's ultimately accountable to the functioning of, for the functioning of the board, of the corporation.
I've got no doubt, and if I suggested that he wasn't entitled to see it, that's not what I was. If you thought I was suggesting that, that's not what I'm suggesting. But
so if you're saying the corporation is not invited, but the chairman is, why don't you just give all the documents to this thing and tell him, look here, don't produce X, Y, and Z, produce the following.
Because
I'm sure the chairman will accept your explanations if there's very sensitive matters insofar as contracts are concerned.
Judge, this is more than merely saying, why don't you do this? We are entitled, we are separate to...
Entitled to what?
To protect our own commercial interests.
No, you're not entitled to protect them. You're entitled, the board is an organ, as it said correctly, it is an asset of all South Africans. This is not a board in vacuum. This is a board which represents a major asset in this country. And now you use technical arguments to say why it can't produce documents, rather than saying, okay, if documents are sensitive, we don't disclose them. I'll read to you what I'm saying, who you represent. If you look at the Act, it says who you are. And 13B of the Constitution of the boards of the board of the
13B of the Act.
SABC talks clearly of transparency and openness.
Sorry, what are you referring to, Judge?
To the manner in which the board is run.
Sorry, 13B of...
Yeah, of the Act, the SABC Act. The corporation must comply with the charter as outlined in this part. What does the charter say?
The charter is dealt with, Judge, in section 6 of the Act, Broadcasting Act.
Section?
6.
You see, it says very clearly that the function of the corporation is to advance the national and public interest. Now, shouldn't all of this be subordinate to the national and public interest? Not what your chairman says, not what the board says, but what South Africa requires in this instance, the national and the public interest requires.
But that can't wish away my...
No, no, wishing away what you say.
The proposition I made to you earlier, submission.
No, I'm wishing into being your cooperation.
The submission I made, Judge, was that these are factual inquiries. And you can't subsume that in a generalized, what is in the best interests of South Africa. Yeah, because that is not fair to the subjects of the inquiry.
But I'm saying it in the context of what is happening here. I'm trying to think as much as I can in your favor, but my mind leads to different conclusions consistently.
You see, Judge, my learned junior points out to me section 9 of the Act, which is in terms to the effect that a corporation must consist of two separate operational divisions namely a public service division and a commercial service division. And the public and commercial service divisions must be separately administered, and a separate set of financial records and accounts are to be kept in respect of each such division.
Yeah, that's how it's run.
That's how it must be run.
That's your two different operational divisions.
So the one,
But both sections are subordinate to the charter. In other words, subordinate to national public interest.
But it's also
it
the
may be that commercial interests may dictate that certain documents not be, but that you can argue, that you can tell the chairman, look here, commercial interests as such, we can't
but we
disclose
must, be
document
allowed,
A.
we must be allowed to be there, Judge.
No, but the chairman can do that.
No, the chairman. Judge, why should the chairman have to do that when we have our own executives?
I'm sure your executive can be a witness. Isn't he on the list of witnesses?
No, he's not.
You can put him on the list of witnesses.
But Judge, I've made my submissions. Can I refer you to the last point that I want to make? And that refers to, well, I want to refer, if I can, to the matter of the prayer, the Truth and Reconciliation Commission, which is referred to at page 14 of my learned friend Mr. Potgieter's Heads of Argument, para 26.
The Dupree case, I see.
The Dupree case is the case that I was involved in with Mr. Advocate Albertus for the TRC. And the quote that you find at page 14, Judge.
Where is it in your? Is it in your?
No, it's not in our heads. It's on page 91 of the bundle.
Bundle.
But do you have Mr. Potgieter's heads, Judge?
I do have spots here.
If you look at page 14, you'll see the quote that he's got. And the quote is from a judgment in the matter of Pergamon Press by Lord Denning,
Master of the Rolls.
Master of the Rolls. And the quote goes on, this inquiry was not a court of law, it was an investigation in the public interest, along the lines that you are putting to me, Judge, in which all should surely cooperate as they promised to do. Counsel for the inspectors went too far on the other side. He did suggest that in point of law, the inspectors were not bound by the rules of natural justice. He submitted that when there was no determination or decision, but only an investigation or inquiry, the rules of justice did not apply. That resonates the argument you've heard, or will hear from the other respondents. I cannot accept counsel for inspector submission. It is true, of course, that the inspectors are not a court of law. Their proceedings are not judicial proceedings. They are not even quasi-judicial, for they decide nothing, they determine nothing, they only investigate and report. Now, unfortunately, the quote doesn't continue, because if you now look at page 91 of our bundle, Judge, you will find that the quote goes on to say the following. But this should not lead us to minimize the significance.
We're on page 91?
Page 91 of the bundle, at the bottom of page 232, against letter J. This should not lead us to minimize the significance of their task. They have to make a report, and this speaks as well to this committee, which may have wide repercussions. They may, if they think fit, make findings of fact, which are very damaging to those in their name. They may accuse some, they may condemn others, they may ruin reputations or careers. Their report may lead to judicial proceedings, it may expose persons to criminal proceedings or to civil action. Seeing that their work and their report may lead to such consequences, I'm clearly of opinion that the inspectors must act fairly. And
well,
then,
the determining criteria is fairly.
I'm sorry, Judge?
They must act fairly.
That's correct.
So.
And the question is whether they can, under these circumstances, act fairly. And then from our point of view, if I can just take you to what Corbett CJ says, against letter F, what is fairness demand in the circumstances of the present case? That is a critical question. Section 32 requires that persons detrimentally implicated should be afforded the opportunity subsequently to submit representations or to give evidence. But does that exhaust the requirements of fairness? The appellant say no, and he says, I agree. And then it goes on about the timeliness and reasonable notice of a hearing. The person likely to be implicated is thereby, I'm now reading against letter I, Judge. The person likely to be implicated is thereby enabled to be personally present and or to be legally represented at the hearing. This will enable him and or his legal representatives to actually hear the implicating evidence and see the demeanour of the relevant witness or witnesses. Conceivably, as pointed out by King J, the implicated person might be able readily to rebut the allegations of the witness. In such a case, the committee might well be under duty to hear the rebutting evidence forthwith or to permit immediate cross-examination, etc., etc. That is the nature of the hearing that we seek.
Yeah, but look here, parliamentary committee, are you suggesting that a person's name should be permitted to cross-examine witnesses?
Yes, Judge.
Chato, I have no idea how parliamentary hearings are conducted.
Anyone implicated should be allowed to defend themselves.
Yes, but are parliamentary proceedings conducted in that way?
If it's going to be fair, Judge, it should be.
But are they?
I've no idea. I don't have experience of other parliamentary.
As far as I know, they're not. You don't have a court of law situation where you cross-examine witnesses.
But that's
This
being
is
allowed.
not the TRC situation.
But Judge,
All the requirements, general requirement of fairness, that I accept, that they should be fair to everybody.
But Judge,
That even if you have preconceived views, you should let the people speak, hear them, and if there is something, if they say something, it may incriminate them in the criminal proceedings, it may warn them of that.
Judge,
But that's about it.
I know. Judge, in this case, this committee understands its obligation to be to allow people to cross-examine and to
Yes.
be legally represented. You find that at page 33 of the papers.
Yes, but that's, sorry, where does it say?
Page 33 of the papers, which is the letter addressed to Professor Maguvhe, notifying him of the inquiry on numbered page 33, Judge, the third
Yes,
page.
you're entitled to be representation at the board's expense.
You're correct.
But that doesn't mean you're entitled to cross-examine witnesses.
Well, that's what it says in the next paragraph. The board may call witnesses to present documentary and oral evidence of the hearings. In the event that a witness implicates the board will be given an opportunity to cross-examine the witness. Furthermore, should the committee be in possession of a
No,
statement...
the board will be given an opportunity.
Precisely, Judge. That's our complaint.
Yeah.
The board is going to be given the opportunity to cross-examine witnesses, not the corporation. That is the very basis of our complaint. That all these rights are being afforded to the board, not to the corporation. Judge, we've prepared a draft order which we ask that you consider making in the event that the application fails, the application by the applicant fails. Could ask leave to hand it up.
It's a new one, Mr. James.
I'm sorry, Judge.
An order in the event of the...
In the event of the application failing and this board remaining in existence, we submit that given what has occurred, you should consider making an order in these terms.
But shouldn't you have given them advance notice about this?
We have. We've said it in our affidavit, Judge. And all that we ask for are the rights that are afforded other participants, as you will see from the order.
Mr. Potgieter, have you seen this document?
It's just been handed to me, my lord, but I will deal with it.
That will you will have to take instructions on this.
Yes, yes.
Because if he is correct, it will make these proceedings into long, protracted proceedings.
Yes, no. We will argue against that, my lord.
But first take instructions.
Yes. But certainly we oppose what they are suggesting.
Mr. Jamie, you done?
I'm done, Judge. Just to make one point, you've indicated that if this was allowed, it would make the proceedings protracted.
Yeah.
With respect, we're asking for the same rights that other participants have been afforded. So if we're entitled to be there, then we should have these procedural rights. And there's no reason not to give them to us. Those are submissions.
So I'm just thinking of the implications of this. there'd be wide-ranging implications.
It's the right to be present, Judge. It's the same rights that I've just referred to on page 33. So for the confidentiality.
What you're asking for, the inquiry to be converted effectively into a trial of the SABC.
No, Judge, with respect, I'm not.
With the right to call witnesses, the right to cross-examine, all the law requires is fairness, not the... well, think about this in the course
Judge,
of the
I've just pointed out that these rights, we're not asking for rights that the committee is not prepared to give. At page 33, you see these rights are given to participants.
I noticed that. Yeah,
so what we're asking is nothing new. But if we are entitled to be there, we should have the same rights. And that's all we ask for. And Judge, apropos...
But this is not an inquiry...
And Judge, can I just indicate to you one thing, and it's an indication of predisposition we submit along the lines of bias. We quoted in paragraph 6 of our heads, where the chairperson of the committee said, in public, in a statement, that the committee would consider requests from individuals to give evidence in camera, but not from state institutions. So there you have a flat, bold statement by the chairperson.
Where do you see that?
It's referred to, Judge, in para 18 of our affidavit, but it's also quoted in page 6 of the heads of argument, our heads of argument. And it's in light thereof that we asked for the relief in 1.4 of this draft order. And all that we're asking for, Judge, we're not asking that we be entitled to it, as you can see. We simply ask that we be allowed to ask for it, because given that statement, it seems the door's been shut on any state institution, which includes the SABC, from asking that it be held in camera.
But this is not an inquiry into the SABC, it's inquiry into the board, isn't it?
Yes, but if there's a reason, Judge, a valid legal reason why we are entitled to say we don't want our documents to be made public, so if you're going to hear evidence of these
You're not a
documents,
party to these proceedings,
we are not a party.
to the proceedings before the National Assembly,
We are not a party.
the bodies.
But I've explained our interest, Judge.
Yeah, we clearly have an interest.
But that is what we asked for, and those are our submissions.
Thank you, Mr. James.
So please.
Mr. Botkhita.
Thank you, my lord.
Mr. Botkhita, what was the last suggestion made by... Can I adjourn for 10 minutes while you take instructions?
I can say...
As to whether...
yes?
It's a question which you have...
With regard to the draft order?
With regard to what Mr. Jamie suggested, that the corporation be allowed to be present, to cross-examine witnesses, to lead the witnesses, in addition to what the committee may call.
Yes. No, I can approach my client again, but my instructions have been quite clear that they are not acceding to the position that the corporation is adopting. They're not the party to the inquiry, my lord. The inquiry is in terms of 15A1B.
Okay, I'm looking for an excuse to adjourn for 5 minutes.
Okay.
Call adjourn for 5 minutes.
You're watching SABC News. Now, these are live visuals coming out of the Western Cape High Court, where the SABC board chairperson, that's Professor Mbulaheni Maguvhe's urgent application interdict to stop a parliamentary inquiry into the national broadcaster is being heard. Well, proceedings have been adjourned for 5 to 10 minutes. Council have been busy making their submissions to Judge Siraj Desai, the parliamentary inquiry into this into the national broadcaster, of course, is due to start on Tuesday already. Now, Maguvhe also wants members of parliament who are on the ad hoc committee disqualified from being members of the committee set up to inquire into the SABC board's fitness to hold office. Now, earlier we also heard from Advocate Thabani Masuku for Maguvhe, arguing that the ad hoc committee will not be impartial and unbiased and thus should be reconstituted, as he will not get a fair hearing. Now, you'll recall in November, the Communications Portfolio Committee decided to initiate an inquiry into the fitness of the SABC board. It then appointed the ad hoc committee led by Vincent Smith to conduct this particular inquiry. Maguvhe has said in court papers already that the ad hoc committee, which is led by Smith, be reconstituted. Now, the committee is supposed to start its work on Tuesday already, we understand, and then it will run on for 2 weeks. We also understand that Mbulaheni Maguvhe, Speaker of Parliament, is the first respondent, with Secretary to Parliament Gengezi Mgitlana as the second respondent. The third respondent is the ad hoc committee. Now, we'll take you back to the Western Cape High Court as soon as the court is back in session. But for now, I understand let's take a short break. Well, before we go to a break, some other news making headlines. The Nelson Mandela Children's Hospital Trust is celebrating the completion of the construction of its hospital in Parkview, Johannesburg. Now, this milestone comes 3 days before the 3rd anniversary of the passing of former President and international peace icon Nelson Mandela, whose dream has finally come true. 1.4 billion rand was raised to build the institution. Additional funding came from ordinary South Africans themselves. The hospital is expected to officially admit its first patients early next year. The 200-bed facility will serve as a centre for paediatric care and research and training, and will operate as a referral hospital as well. The hospital will work together with doctors and professors as well as for training.
It's been heartwarming to have seen the project from 2009 when the first sorting happened to see it today being completed. Indeed, this is going to be our benchmark going forward. It's just been incredible.
Yeah, and it's so important because when you look at the continent, I think there are only 4 children's hospitals on the continent, this being the 5th. There is one in Cape Town, but this now being in... Yeah, so this is the 2nd in South Africa, but it's set to help also others in sub-Saharan.
Yes, it's the 2nd best, of course. It may be the 5th in Africa, but I think that's the best out of them all. And we're really excited about this because the services that are going to be provided are very specialized services. I think we can only say this is really a benchmark from all round, from infrastructure to medical care to everything else. And I think we're simply saying to the continent and the world, watch out. And I think South Africa and Gauteng in particular, we're very excited the fact about the different donors who really put every cent into this for us to have this building to serve the children of sub-Saharan Africa.
Well, a student has now been arrested for allegedly killing his roommate in the early hours of this morning. That incident took place at a residence of the Tshwane University of Technology's main campus in Pretoria. The accused is said to have found that the deceased locked the room with a different padlock. He then got hold of a bolt cutter and an argument ensued with the deceased. It's alleged that the assailant attacked the deceased with a bolt cutter, beating him to death. DNA results have confirmed that the body of a toddler that was recovered near the Yixkay River last month are indeed those of 3-year-old Everett Chauke. The news was broken to the Chauke family at the Bramley police station in Johannesburg earlier today.
The Chauke family arrived here early this morning, anxious but hopeful. It's been a difficult 4 weeks for the family. You would recall that the child was washed away during the flash floods in Alexandra last month that left 6 people dead. She was eventually found on the banks of the Yixkay River in Patlu on the 22nd of November.
Indeed, the baby who was found on the 22nd of November belongs to the family. And we are happy the case will be closed. As for now, the process will be, they will go back to the government mortuary where they will have to make some arrangements of removing the body for burial.
A confirmation that's brought grief, but also a sense of relief. The family says it can now find closure.
I've been crying because I was not sure if her body would be found. Rescuers did their best, yet I was afraid what would happen to the body.
The 3-year-old will be laid to rest next week. Mbulaheni Maguvhe, SABC News, Bromley Police Station in Johannesburg.
Your weather details after this. I'll be back with more news at the top of the hour.